SJC-12881, estate of Jacqueline and Kendall v. Mass Health.
So first we have Ms. Fine.
You need to turn on your mic. There you go.
Good morning, Your Honors. How I wish it were true. Good morning, Your Honors, and may it please the court. Can you hear me? Can you hear me?
I'm sorry, we can. There's a bit of reverb from the last thing. So
I'm going to ask Justice Jacqueline to take over for my meeting.
You know what I mean?
Yeah.
Right. So I think if you plow, let's
Can you hear me now?
right. Let's do this, Mr. Keneal. If you could give Ms. Fine 10 more new minutes.
Oh, thank you. Can you hear me now?
We can, and you may proceed now.
I had forgotten to turn off the Suffolk website. Good morning, Your Honors. My name is Meredith Fine. I represent the estate of Jacqueline and Kendall. I've donated some of my time to attorney Patricia Keene Martin on behalf of the Amici. If the court has specific questions about Mass Health, I'll do my best to answer them, but you might be better served saving them for the expert. There are two big problems with giving Mass Health unlimited time to file claims against an estate. One problem is a title problem, and the other is a problem with personal representative's liability. The title problem is this. If there is real estate in an estate, the title passes to the heirs immediately upon the decedent's death. But the estate retains an interest in that real estate in order to pay claims and estate expenses. So as long as the estate is open, the estate has an interest in the real estate. And so if the estate is never closed, that interest in the real estate is never extinguished. That's problem number one. Problem number two is that personal representatives have personal liability if they misspend estate assets. And Mass Health can claw back benefits that have already been distributed to the heirs and devisees.
So Counsel, may I ask you a question? Is your position then that there has to be a deadline? Because otherwise, if we adopt the position of Mass Health, we're going to eliminate the statute of limitations or the statute of repose, and these things will be open forever, and there'll be no closure or certainty.
Exactly. The legislature weighed these two issues. They gave Mass Health extra time, but they put in a statute of repose to protect, to clear titles and to protect personal representatives. 20 years from now, Mass Health could find an unpaid claim in its file and try to claw back those, what's been distributed already, and try to bring in the personal representative 10, 20 years later. Who would serve as a personal representative under those circumstances? And you don't even know there might be a Mass Health claim. So this applies to anybody serving as a personal representative. Mass Health makes three main arguments that I'd like to address. One is about notice. If somebody is a resident of a nursing home and receiving benefits and they die, the nursing home notifies Mass Health of the death. In the case of Ms. Kendall, she was never in a nursing home. She received all of her care in community settings. And we never had to open probate in the end. And she died intestate without a will. So Mass Health's concern here is, how does it get notice when somebody is not in a nursing home and never needs to go to the probate court? Well, on the ground, Mass Health already has plenty of access to that kind of information. First of all, Mass Health beneficiaries have to fill out a annual eligibility claim. Mass Health has access to the Social Security death index. And Mass Health already has 2 more years than any other creditor. The second issue that Mass Health brings up is
Can I ask a question about, so I understand the need for a statute of limitations or a statute of repose. I'm trying to understand whether there's a possibility of gaming the system, because all of us are paying for that free care in the nursing homes and other things. So tell me how Mass Health, how we protect against the clever lawyer like you who says, wait 3 years and you get to have your cake and eat it too. So how is the state protected against that? Because I'd like to make sure I understand that you can't prevent us from getting that money if we're entitled to it.
First of all, the reporter's notes address that concern. The reporter's notes to Section 3803 say that the legislature considered this possibility that people would kind of squat in these houses until the 3 years were up. And the legislature decided that it's up to creditors to pursue their claims. Second of all, you have to look at the population that we're dealing
So
with.
tell me, Mass Health can protect itself. If I have an attentive state government, they can prevent you from using this 3-year rule. Meaning they can force the issue. Mass Health. Go ahead. Tell me how Mass Health protects
Mass
it.
Health has the ability to open estates, as any creditor does.
So as long as they know the person has died,
Okay.
they can open an estate and force the issue so that clever lawyers like you can't prevent us from recouping the cost of the nursing home. Is that right?
That's exactly right.
Okay.
And on the ground, you need to look at the population that we're talking about here. Many of these houses stay in people's families for generations. When the beneficiary dies, it just goes to their kids. The kids stay in the house. These are not folks who have clever lawyers like me on their speed dial. And again, I would point to the reporter's notes that the legislature weighed this risk and offset this risk in part by giving Mass Health extra time. Now, the estate's problem is that there is nobody with the authority to pay this claim. The legislature, can I speak? I want to make sure Attorney K. Martin can speak.
You still have 3.5 minutes or so.
Okay, well, I had given her 5 minutes of my time, so I want to make sure she can still speak.
Right,
I'll
we
wrap-
calculated that into the timer.
Okay, thank you.
Yeah, right.
So why would the legislature create a system where, on the one hand, Mass Health has infinite time to file their claim, and on the other hand, there's nobody to pay the claim? Why would the legislature create such a inconsistent system? Well, they didn't create an inconsistent system. The legislature took 20 years to pass the Mass Probate Code was considered for 20 years. Mass Health had plenty of time, plenty of input into that process. There have been 2 amendments since the Probate Code went into effect in 2012. One set of amendments emphasized how limited the role of the personal representative is in latent limited testacies. And the second set of amendments came from Mass Health itself and did not address this question. Mass Health brought forward its amendments in 2015. By 2015, at least one other state, Nebraska, had applied this same language to Medicaid claims in 2012. So Mass Health had plenty of input into the probate code. Mass Health was aware or should have been aware that other states were applying this to Medicaid claims. Mass Health put in its own amendments and did not address this issue. Now, this court
Ms. Fine, couldn't the answer be that they believed 803F provided it, and that the concern is that wealthy people can go to a good attorney and be able to preserve their home, and everybody else has to pay for the nursing home because they could afford a good lawyer to preserve their home.
Well,
And they didn't think they had the problem because they had 803F.
Thank you for the opportunity to address 803F. Mass Health looks at 803F as an escape hatch. And 803F is not an escape hatch. It's part of the connective tissue that connects the probate code to the Mass Health Statute 118E. And what 803F does That's where Mass Health actually gets the extra time. There's nothing in the Mass Probate Code, and there's nothing in the Mass Health statute that exempts Mass Health from the statute of repose. What 803F does is give, by referring to section 118E, section 32 of the Mass Health statute, there's a section in there that says that Mass Health can open probate, get a special administrator appointed, and that administrator is not bound by the date of death. Now, first of all, the special administrator is just a different flavor of personal representative, but there's still a personal representative. There's nothing exempting a special administrator from the duties and obligations that cover any personal administrator. But second of all, that section says that the personal administrator is not tied to the date of death, except for the statute of repose. The Mass Probate Code governs every single thing about estates.
So you would just to simplify it, you would say 803F is not an exception to the 3 years, but it's an exception to the 1 year because of the position that Mass Health is in.
That's exactly right. If the legislature had intended to exempt Mass Health from the statute of repose, it had 20 years to say so, and it didn't. The legislature knew perfectly well how to exempt Mass Health or how to give Mass Health special treatment. The legislature balanced competing policy interests here. They did it with a lot of input, with a lot of time, and at some point, estates need to close, and personal representatives need to be relieved of liability, and titles need to be clear. And there's no reason for any court to impute language into the probate code to solve a problem that doesn't exist. There's no reason to disturb how the legislature has balanced the different policy interests here.
Any further questions of Ms. Fine? Thank you, Ms. Fine.
Thank you.
Ms. Keen Martin, please. We have to unmute first.
Can't hear her.
Unmute.
Be good.
She,
Nope, now you're not.
I'm sorry, Ms. Keen, we're having, it might be on our end because you're not shown as being muted, but we can't hear you.
No.
No. Mr. Cornelius, is Jeff available?
I'll check Justice Gaziano. What Attorney Keen Martin can do as well. My guess is that it's on her end because we tested all of this last week. She's got to try a different way of getting her audio going. There is an alternative as well. She can dial in to a phone number that she has actually.
She has headphones on. Let's see if this works.
Nope.
We cannot still hear you. Ms. Keen Martin, perhaps if you could dial in on a telephone line.
Can you hear us?
She can't. She's responding to us. I assume you can hear us. If you can, and she's nodding, right? So.
Okay.
We're still not unable to hear you, Ms. Martin.
Horrific. This is absolutely horrific.
Ms. Keene, I think we can get you right now. Can you hear us?
Can you hear me?
We
Yeah.
can.
You hear me say this is horrific?
Yes.
We did, but we understand your frustration, and I'm going to tell you, just take a deep breath and don't worry about it, okay?
Right.
Oh, thank you, Your Honor.
You're welcome.
All right, we will start again.
We'll start again at 5 minutes, and no apologies necessary. Given
I appreciate your patience, and the clerk has been simply phenomenal. I can't even give him enough credit for all the patience he has had. May it please the court, my name is Patricia Keene Martin, and I am here on behalf of the Massachusetts chapter of the National Academy of Elder Law Attorneys, the Real Estate Bar, the Abstract Club, with a letter of support from the Massachusetts Bar Association to answer the court's question as to whether or not Mass Health is entitled to recover benefits from a decedent's estate filed more than 3 years after the decedent's death, including whether or not the Uniform Probate Code, Section 190B 3108 precludes such recovery. Our collective answer is that the plain language of 190B 3108 demonstrates that it is an absolute extinguishment of the authority conveyed to a personal representative, and therefore does preclude recovery by Mass Health. Further, 3803, with its reference to 118E, does not create any exceptions or convey any additional authority to the personal representative to act beyond the 3-year extinguishment. I had a whole speech prepared, but I would like to address Attorney Fine did a masterful job walking through the Mass Health process in the reasons that this is a statute opposed and an absolute extinguishment of authority conveyed to a personal representative. I would like to add that the court understand, one, as Attorney Fine touched upon, this class of people are not people that are rushing to attorneys. And in addition, they often have exceptions. Within the regulations, there are exceptions and waivers that these people are entitled to that they may not even know that they have. So what the legislature did is that they balanced, as Attorney Fine said, the need of judiciary to bring forward right claims so that, real estate bar is satisfied, that the medical documents don't have to be held on for 20 years.
I get your perspective. I want you to step into the shoes of the opposite side, because I get why Reba and everybody else doesn't want certainty and settled decisions. Tell me how we protect the Commonwealth. How does the Commonwealth protect itself? Give me, if I'm on the opposite side, because undisputed, the Commonwealth's entitled to be compensated for this money. And if this were done properly, right, the family would not get the full benefit of this money. It would be $108,000, whatever it is, will be given over to the state, right? Or whatever that number is. So tell me how the state protects its interest, because I care that all of us are paying for this. So tell me how the state protects itself.
So, Your Honor, this statute, in fact, encourages that. The idea of the statute is for the Commonwealth to step up, for creditors to step up, because people don't always do what they're supposed to. So they have the ability to step up within a 3-year period of time and file for a public administrator. They also have a bunch of other advantages as a creditor, as a sort of super creditor. They have priorities over other creditors. They have notice provisions that other people don't have. They have constructive and actual notice. So in some ways, what they're asking this court to do is to fix an administrative issue. They just don't want to do it within a 3-year period of time, despite having no...
So this is basically inattentive or sloppy work on the state is what produces this 3-year time delay. So I have less sympathy if the state can do it and doesn't do its business than I do if the state is being gamed by the system. So tell me how is it that we basically have a sloppy state government that's not
I don't want to say that, Your Honor. They have the tools to move forward if they want to. So whether or not it's sloppy, whether or not they have other fish to fry, whether or not they just don't get around to it, that's not a question that I'm prepared to pose. What I do know,
they want the money in every case, right? I mean, state government needs the money and wants the money in every case. So I'm just trying to understand, it must be a lack of attention then, you're telling me. Is that what you're saying?
They're not moving forward in a timely manner. So it is, they have every resource available to do that, but at some level, it is an administrative fix. They have every opportunity to move forward in a timely manner, which is 3 years, which is ample time. It's 2 years more than you'd give your landscaper that you owed money to, who doesn't even have constructive notice, right? So I don't want to besmirch the Commonwealth, because I understand, as you would ask me to, that they have an interest in recovering. This law in the MUPC gives them that ability to recover within a reasonable period of time, which is 3 years. But after that, it has to close. It has to be an end. If no one brings it forward, then for all the other interests that the legislature had to meld together to come forward with the MUPC, that's the end. Shall have no authority conveyed except for to confirm title or pay administration expenses. Shall have no authority. It is clear, it is plain, there's no exception. It is the umbrella of all authority given. 803 does not convey authority. 118E does not convey authority. It is clear, it is there, and they have ample time to move forward. And if that means they need to tighten up their process, then that is in fact what they need to do, Your Honor. So I appreciate your patience with my technical issues. I am going over. I would like to confirm that Amici does request that this court adopt the position that 3108 does in fact serve as an absolute extinguishment of all rights to be conveyed to the personal representative, which would preclude creditors, including Mass Health. Thank you.
Thank you, Ms. Keen-Martin. Mr. Marks.
Thank you, Your Honors. May it please the court, David Marks, Assistant Attorney General for Mass Health. As you well know, Mass Health is a program of medical insurance for the truly financially needy. However, in determining eligibility for Mass Health, one of the things both the federal and the state law provide is that principal residences can be excluded from counting of assets under a variety of circumstances, where the member intends to live in the primary residence or return to the primary residence, where the spouse is living and lives in the residence, where other individuals, children, siblings might live in the residence. And Mass Health allows a principal residence to be excluded from the counting of assets up to the value of over $800,000. In other words, if someone owns a house worth up to $800,000, that residence can be excluded from the counting of assets.
Okay,
However,
maybe I'm missing the point, Attorney Marks, but what does that have to, I mean, whether it's 800, 500, 100, what relevance does that have if we're dealing here with statute of limitations, statute of repose, and whether the agency can find out if somebody has passed away easily enough to assert their rights?
yes. So the point is that both federal and state law intend that Mass Health use a state recovery, have in place in a state recovery program, and use it to pursue recovery of benefits paid under certain circumstances. And the legislature in 190B section 3803 and 118E sections 31 and 32 has set up a very particular, detailed, thoughtful program for enabling Mass Health to assert its estate recovery rights against probate estates.
Mm-hmm.
And so the argument that 190B 3108 that provides for this limitation on the powers of a personal representative for estates opened more than 3 years after the death, is a general statute and does not attend, if you will, Mass Health's needs to protect its estate recovery.
Well, I understand that, and I understand the specific language on in statutory interpretation and general language and all that. But when I look at 190B, section 3803, which sends me to 118E, section 32, there's two components, and it doesn't seem that the Mass Health met either one of them. They weren't within 4 months of the appointment, and they weren't within a year of the death.
In this case, Mass Health presented its claim well within 4 months of the approval of the personal representative's bond.
Okay.
In fact, in this case, the personal representative's bond hasn't even been approved yet. So,
okay.
In any event, the Mass Health is well within the time frame there.
Okay.
So
isn't there chaos if we don't? I mean, you can enforce this within 3 years. You have all kinds of ways of doing this if you proceed right in a timely way. And if you wait indefinitely, we're going to have estates passing. I mean, we're going to have people having transferred the property to people who are outside the family, and you're going to be collecting. How is that all going to work? Isn't it up to you to act within 3 years? What's so hard about that?
The legislature has specifically provided that Mass Health has 4 months from the time of the approval of the bond of the personal representative. Why? Because the legislature understands and anticipates that Mass Health does not necessarily normally obtain notice of the death. The entire argument of the estate is based on this assumption that Mass Health gets notice of the death. The problem is that this is not borne out in any facts or in any law. There is no legal provision that provides Mass Health a way to learn of a death other than the notice provisions in the probate code and in section 32 of 118.
Really? So even though you're providing benefits, I mean, do dead people keep getting benefits for years without you doing something to turn them off? I assume the answer to that is no, right?
Rather, Your Honor, just because benefits stop does not mean that someone died. And this is what the estate is saying. Mass Health is automatically on notice that someone died when benefits stop. Mm-hmm. This is not necessarily the case. For example, in Ms. Kendall's case, she stopped receiving benefits because I assume one possibility is that she recovered. She didn't need healthcare benefits. Or one could no longer be financially eligible, in which case benefits would stop. What is important to recognize is that the legislature created an entire scheme that turns in great measure on notice to Mass Health of the petition of the estate.
So let me just probe for a second. So the 4-month period, I understand you met the 4-month period, not a problem. Why then, if that's the case, why is the Abstract Club and REBA, why are they so upset? Because is the 4-month period of time preventing this type of catastrophe where estates get transferred and everything else because nothing's happened within the 4 months? Is that why there's not a downside to going your way? Is that clear? I'm not sure I expressed that very clearly.
I'm going to answer whatever question I heard you ask, Your Honor. there is no question that the 4-month period protects Mass Health from an intentional delay in probating estates. There is no question.
No, I understand. I'm trying to ask you to look from the same questions I was asking your sisters. I want you to look from the other side of the V for a second and tell me why they're protected. Does the 4-month period mean that we're not going to have, 40 years later, after an estate has been transferred or whatever, are they protected? Are they overreacting because their interests are protected by the fact that you have to act within 4 months from the appointment of the bond of the personal representative?
If the problem is this assumption that if the 3-year period doesn't apply to Mass Health, that Mass Health will come running in 20 years later and grab some assets.
Mm-hmm.
It doesn't make any sense because if the 4-month period runs from the petition for a probate estate, then whenever that happens, and sometimes heirs wait
Mm-hmm.
to do that, or there's some conflict within a family, whatever the reason people wait to probate an estate, once they do and Mass Health is given notice, that 4-month period is running.
So again, so all these real estate lawyers and trust estate lawyers, they're all overreacting. I'm trying to put you in the shoes of the opposite side, so I understand that they're exaggerating the problems that are caused, because basically this is a frozen estate. Nothing's happened. It can go on for years and years and years, but it's frozen in the family somehow. And that 4-month period means that people besides the family aren't going to be victimized by this. Is that correct? I'm just trying to make sure I understand it. Well, I feel like both sides aren't giving me the other perspective, which is normal, but go ahead.
Well, there is no question that, this is part of the situation with what's remaining in the estate in the case of Mass Health members. It is typically just the primary residence that someone has been living in. There is no incentive to probate an estate simply to deal with that residence if people are happy to continue to live in it. Mm-hmm. In this case, the residence was rented out during this 3-year time period. The point is that, yes, it is true that if the heirs take no steps to probate an estate, and if Mass Health does not learn of a death, which it may not, there is no established way for Mass Health to learn of deaths, then yes, this could go on for years and years and years. No estate is opened. Mass Health doesn't learn of the death, and people are living in the house or renting in the house without having a personal representative appointed.
Right, but you're saying, I just want to fit one last question just to make sure I fully grasp. And you're saying that we shouldn't be concerned because the family who's delayed this probating, and taking advantage of it, are the only people affected by your delayed pursuit of this. We're not going to have innocent third-party victims who bought the house or anything like that. That won't be the case. It's just the family who's manipulated the process that recovery will be taken from. Is that your argument, or am I overstating it?
Well, yes and no. I don't think you're overstating it, but, and this is one of the funny things about adopting the estate's argument here. There is a provision right up front in 118E, section 32, that says that if an estate does not give notice to Mass Health, and the property is transferred, that Mass Health has the right to go after that property in the hands of the the transferee, without regard to the date that the probate estate was opened. Could be years and years and years.
Isn't that the problem, though?
I'm sorry, Your Honor?
Isn't that the problem, that you could have an unwary buyer of the property and then have all of a sudden have Mass Health come after that person? I guess my question to you is, I understand that you said that there's no mechanism right now for Mass Health to be notified of the death of somebody who's getting benefits, but isn't that easily remedied? Isn't there a way for that to happen?
Without regard to whether there's a way for that to happen, that is not what the legislature intended or expected. The legislature.
But that's not what your sisters say, though. They say that you have the opportunity to get what Mass Health has the opportunity to get what it is owed. And after a period of time, we have to close the window because otherwise people are exposed. You have to have an end to the process at some point.
According to filings that Mass Health has made with the legislature, in 2018, for example, there were over 1.8 million members of Mass Health.
Mm-hmm.
There is no organized way for Mass Health to constantly surveil its 1.8 million members to determine when and if someone has died. And the legislature recognizes that. The legislature has used the trigger for the time frame within which Mass Health must pursue a claim, present a claim, and that trigger is notice from the opening of the estate.
I have one question, if that answered your question, Justice Budd.
Yep.
Counsel, can you, if I look at 190 section, is it 190? Yes, section 118E, section 32, and section I, sub I, says that if there's been a year after the death, you have authority to designate a public, Mass Health has an authority to designate a public administrator. That suggests also to me that they're contemplating in this some kind of end of, or some kind of limitation on Mass Health's ability to just come in at any point.
The Mass Health's ability or authority to request the appointment of a public administrator depends on its learning of the death.
Mm.
And the legislature has constructed this scheme with the recognition that Mass Health might not learn of the death. And so it has created a separate alternative time limit for Mass Health to pursue its claim, 4 months, very short, but from the time of the opening of an estate. Why? Because the way the law provides, Mass Health will learn of its opportunity to recover on an estate is by getting notice of the opening of an estate, not necessarily by learning of a death. Mass Health may learn of a death, and it has the right to protect itself by using a public administrator, but the legislature itself has understood that the time limits that apply to Mass Health cannot turn on the date of the death, because otherwise clever estate planning attorneys would advise their clients who are living in the house or renting the house to simply wait 3 years, and by doing so would then defeat Mass Health's ability to seek estate recovery. And that is the problem with reading or with failing to read 803F and 118E section 32 as providing a separate time frame for Mass Health to assert its estate recovery efforts.
I believe Justice Lowy has a question.
Yeah, quickly, thank you, Justice Gaziano. So this sounds a lot like a public policy discussion rather than a statutory interpretation discussion, but as a matter of statutory interpretation, you put all your eggs into the argument that 803F is more specific than 108.4. And the problem with that is that if you can't reconcile them both existing, but you can reconcile them both existing. 803F is a specific provision that gives you not just a year, but 3 years, and within 4 months of the personal representative being appointed. And 1084 says, okay, but it's a hard 3 years because it's a statute of repose. Those statutes can be reconciled. They can be reconciled by giving additional time to Mass Health. And so which is more specific and which is more general doesn't help you as a matter of legislative interpretation. You might make a very compelling argument that you need to have notice. By the way, you could have notice by only not looking at 1.8 million people, but looking at the people who have stopped benefits. But putting notice aside, the problem with your argument is that you can reconcile both statutes, provisions of the statute, so we don't get into general and specific.
Well, here's one way in which, well, you can't reconcile them because as you say, to read the 3-year late and limited provision as applying to Mass Health, that means that Mass Health's ability to pursue estate recovery 4 months after the approval of the bond is destroyed in those cases in which the estate has not been opened within 3 years. So it totally renders that part of Section 32 a nullity. It also renders the requirement to give notice itself a sort of an absurdity. In other words, the statute requires, the statutes, plural, require that in every estate in which there's a petition for the administration of estate, notice is given to Mass Health. Every single estate in Massachusetts, notice is given to Mass Health by certified mail. However, the upshot of the estate's argument here is that for every estate that is petitioned to be opened more than 3 years after the death, that notice is pointless. It is a wasted effort. It is a waste of money. But the law requires it anyway. Why? Mass Health gets a notice 3 years after the death and says, oh, isn't that nice to know? I'll throw that in the garbage. This is the problem. The problem is the legislature has created an entire specific provision scheme for protecting Mass Health's estate recovery efforts, and this general language, there's nothing specific about 803 or 108.4. There's nothing specific about it. It just says personal representatives has limited powers after 3 years after the death. There is no reason to believe that the legislature intended that provision to specifically cut off Mass Health's rights when it, in very specific terms, went out of its way to protect Mass Health's rights in all kinds of other ways. This argument...
You may have answered the question. Is that satisfactory, Justice Lowy?
Yes, thank you very much, Justice Gaziano.
Any further questions of Mr. Marks?
No, thank you.
Okay. Thank you, Mr. Marks.
Thank you, Your Honors. I would rest on my brief.
So we'll take our 5-minute break while Clerk Keneally sets up the next case.